Hey y'all, what is up? Welcome to my channel, or welcome back to my channel. It really just depends if you're new here or not. Now, yesterday's video, for those of you who are new here and did not see that, or if you already are a subscriber and missed out on that video, turn on post notifications. But we talked about Eugenia Cooney's dad, Kevin Cooney. Not a lot is known about him, but very few things. And we started to dive further into his crazy, violent criminal past. Now, as crazy as it is, we talked about the attempted unaliving of Deb by him, and that was something that honestly I did not expect. That made my jaw drop whenever I was reading it, made a video about it. Y'all had a lot of opinions on it as well. We found more. I've always seen YouTube channels saying that like their audience is like detectives and they always dig up stuff that they don't know how they found it. And I was like, that's so crazy, because people really do find the most bizarre shit. But y'all really are detectives. Y'all are out here digging up like literally everything left and right. Like there's gonna be no dirt left in this whenever we're done. So a subscriber had sent me the tea that we talked about yesterday from the 90s news articles, and another subscriber had sent me some really crazy new information. Now, going off of what we talked about yesterday, we talked about how Deb and Kevin both seemingly had an alcohol problem whenever they were younger, in the 90s. And seems to be going on. It's like an ongoing thing with them. I don't think that they're currently going through any type of like alcohol addiction, but back in the day it was something that they struggled with on and off. Before we start diving into the actual video, I just want to say everything today, this is all alleged. This is stuff that you guys and myself see on the internet. We have our own opinions on it. All we're going to be doing today is talking about stuff that is already in the public domain, and again, it's just alleged. Not the random the random Godzilla noise in the background. We're just gonna move past that. Now, the first document we're gonna look at today, and again, this is public record. This is stuff y'all can find for yourself out there on the internet. It's not anything that we magically curated. This is something that's already out there on the internet. It's something that y'all can find if you search this document. And I'm not gonna lie, I wasn't too sure what it was when I was reading over it, because in my head it seemed like it was something that it probably wasn't. So I did reach out to Jadedness and asked her what she thinks it is. She gave me her answer. So we're going to look at this document, then go over what it is. Now, the document reads as follows: State of Connecticut specific power of attorney. Now, I myself wanted to take an extra look at what a power of attorney is, just so I came in here with like clear sound on what I want to say and how I want to give commentary. But for those of y'all who are unfamiliar, we're going to be taking a look at what a power of attorney is and what they actually do. Now, it says the POA, aka power of attorney, is a legal document that grants one person, the agent, the authority to act on behalf of another person, the principal. This can encompass various actions from financial decisions to healthcare matters. The POA allows the agent to make choices that the principal would otherwise make, often for reasons of convenience, incapacity, or other circumstances. So the principal in this document would be Deb, the person who grants the power of attorney. The agent would be Kevin in this situation, the person who is given the authority to act on the principal's behalf. There are different types of POAs. And for the power of attorney role, that would be either the financial, the healthcare. Then there's also the general power of attorney or the limited or special power of attorney. And the limited or special would be what grants the agent authority only for specific actions or purposes. The key points of having a power of attorney here say the principal must be 18 years old and of sound mind. The power of attorney must be in writing and signed by the principal. In some states, it says also that the POA may also need to be witnessed and or notarized. And what's interesting for this one is Eugenia Cooney was actually the witness who followed through with signing this document for her parents. Now that we have that out of the way, we're going to be reading this document. And again, it states, State of Connecticut specific power of attorney. So this would be a specific case. Again, we listed off different types of power of attorneys, but this one right here would fall under the specific POA category. And it says, I, Deborah S. Cooney, appoint Kevin M. Cooney as my agent, attorney in fact, to act for me in any lawful way with respect to the following specific and limited purposes. Power of attorney is limited to the refinance of, and then their home address with Wells Fargo Bank, N.A., its successors and or assigns, loan number. The power of attorney is effective immediately as of the date of my signature below, and it shall not terminate in any event of my disability, incapacity, or incompetence. I agree that any third party who receives a copy of this document may act under it. Revocation of the power of attorney is not effective as to a third party until the third party learns of the something. I'm so sorry, I can't see that word. Now it also says, I agree to indemnify the third party for any claims that arise against the third party because of something on this power of attorney. This power of attorney is written and executed in the state of Connecticut, something interpreted in accordance with the laws of that state. And then it says here, in witness whereof I have hereunto set my hand to the date specified below. Then, as y'all can see, Deb signed as the principal of this document. Kevin M. Cooney would be the POA in this document. And then, as y'all can see here, there is a witness number 1, which is Eugenia Cooney's signature. I'm not gonna lie, I'm a dumbass when it comes to like specific things such as this. So I had to reach out to Jade and ask her what she thinks that it is, and she says that basically just looks like they were trying to refinance their house, and Deb basically had to just sign for Kevin. That's not exactly what she says, but that's kind of like the rundown of it. They were just basically trying to refinance to get a new home. Now, I've never owned a home. Surprise, I'm young, and the times we live in, I should have bought property when I was a baby. That's honestly, when I was a child, I wish somebody would have just bought me a little property of land for my birthday, honest to God, because nowadays it is like damn near impossible to find something affordable to even get into. Y'all, kind of off topic, I was scrolling looking for homes the other day that was like rent to own or just like to buy outright. There was a, what was it, 3-bedroom, I think 2-bathroom trailer that was selling on, what was it, 4 or 5 acres of land. It wasn't nothing big or special. That was going for over $200,000. And I was like, shut the front door, because there's no way. Anyways, back to my original point. When I think of power of attorney, I always think of like, not just like the finance side of it. I don't know. I just feel like power of attorney is like a very deep thing to have, because then they can make specific decisions for you just from signing that one document. And I understand that it said there it was just to refinance something, but I don't know. I just don't know about that power of attorney situation. Like I said, when I hear power of attorney, my mind goes to crazy places. But anyways, that was that document. I just found it interesting with Kevin being Deb's power of attorney, even though it was just to refinance something. But with that being said, again, that was a public document. Anybody can go and find it. A subscriber did end up sending that to me, and I told them, you know, thanks. I'm going to end up making a video with it. Now, second thing I want to get into is something else a subscriber had sent me. And this is pretty much a drunk driving record of Kevin Cooney. Now, in the last video that I did make about Kevin Cooney, we did talk about the struggle with alcohol, how he had to take a specific medicine, do all types of crazy things to try to get over and kick this addiction with alcohol. He ended up going to a recovery center, did AA, did certain special things that were pretty much court ordered for him to be able to wipe his record clean. Go refer back to that video, y'all. We talked about everything there. But in today's video, we are going to be discussing that in a part 2 because there is updated information on him when it does come to his drunk driving history. Now, the news articles we talked about was originally from the 90s, and that went over him attempting to unalive Deborah. This is all allegedly, again, just for legal reasons, y'all. It's literally in the paper, so it's like found to be true, but just for legal reasons, I don't feel like getting sued. Not today. Yeah, it's in the paper. Y'all know. But that was from the 90s. Then the last drunk driving incident I did hear of Kevin Cooney was from around 2012. It was in the paper again for the state in which he lives in, where they talked about driving on a rim. He was highly intoxicated. He ended up getting arrested for a short period of time and then later released. We're going to be going over this paper here today. Now, somebody can fact check me on the dates if I get this wrong. Please let me know in the comment section, or just correct people if I do say the wrong thing. The date back in 2012 was again in the state of Connecticut, and it was December 23rd of 2012. This right here is actually for drunk driving in Pennsylvania, alleged drunk driving in Pennsylvania, and this was submitted January 28th of 2011, and it was actually filed March 24th of 2011. Now, in the last video that we made, Kevin M. Cooney decided to basically sign a thing that says that he would give urine tests to calculate how much he has in his system of a medicine that was supposed to keep him off of alcohol. So keep that in mind for this. It says, in this appeal, Kevin M. Cooney, the licensee, seeks a review of the order of the court of Common Pleas of Montgomery County trial court that denied his statutory appeal from a 1-year suspension of his driver's license. The Department of Transportation Bureau. Why? Ooh. Borough. That's not it. Why? I know this word. I swear to God, I know this word. My brain's not braining. The Department of Transportation Bureau of Driver, I think that's it, of Driver Licensing suspended licensees' driving privilege for 1 year under 75 PA, C.S, all this stuff, as a result of his refusal to submit to chemical testing. Licensee contends the trial court erred in denying his appeal, where the department failed to establish the arresting officer had reasonable grounds to believe licensee was under the influence of alcohol or a controlled substance. Upon review, we affirm. Previously in Cooney versus Department of Transportation Bureau of Driver Licensing, we reversed a earlier order of the trial court that denied the department a continuance when its sole witness under subpoena could not be located at the time of the hearing. It was later learned that he suffered a medical emergency. That's scary. We also vacated the court's order sustaining licensee's appeal and remanded the case for a hearing on the merits. Okay. Y'all, I'm not saying this is what happened, but y'all ever see the shows where somebody's gonna, like, testify against somebody who has power and, like, money to take care of the situation? And I say take care with a little bunny quotations. And they end up coming up, like, missing or unalived or hurt severely to where they can't attend it. It's giving weird vibes. I'm no way, shape, or form saying that is what's happening. I'm just saying it's a little bit weird. Now we're going to be reading the background. In December of 2008, the department notified licensee of the 1-year suspension of his driving privilege based on his refusal to submit chemical testing after being arrested for DUI. Okay, so I guess this dates back to 2008, and this would be before the incident in 2012. Licensee appealed the suspension to the trial court. At hearing, the witness was Conshohocken police officer David R. Lennon, who testified as follows. On the evening of October 12, 2008, police officer observed a Ford Escape traveling east at a high rate of speed on West 7th Avenue in Conshohocken. Reproduced record RR at 13:08. It continues and says, the vehicle failed to stop for a stop sign. Police officer had trouble catching up to the vehicle but eventually got its license plate number or ID. Police officer followed the vehicle, which stopped at a red light at the intersection of West 9th and Fayette. Although the light turned green, the vehicle sat there for an unreasonable amount of time. When the vehicle proceeded, police officer activated his emergency lights and siren and attempted a stop. However, the driver, later identified as licensee, did not pull over. Because I guess if you have a specific point, if you get to a specific point of money and power, just basic rules don't apply to you. To uphold a suspension under 75 PA C.S, these numbers, the department must establish at the appeal hearing that licensee was arrested for DUI by a police officer who had reasonable grounds to believe that the licensee was operating a vehicle while under the influence of alcohol or a controlled substance. And then it says here 2 was asked to submit a chemical test, or 3 refused to do so. And 4 was warned that a refusal would result in a license suspension. Now, I didn't read this prior, so if I'm like messing stuff up, I do apologize. Again, this is giving another rundown of the situation through the officer's eyes, and it says here, licensee stopped at a red light at West 11th and Fayette at 14A. Police officer still had his lights and siren on, but licensee refused to pull over. The light turned green and licensee continued northbound on Fayette, changing to the inside lane and then back to the outside lane. Police officer then pulled up next to the licensee, who was now driving slowly, and made eye contact with him. Police officer motioned and yelled to licensee to pull over, but he again failed to do so. Police officer then decided to stop licensee, who appeared clearly intoxicated. He pulled his patrol car in front of licensee's vehicle and forced him to stop by the curb. At that time, both police officer and licensee had their windows down. Police officer commanded licensee to put his vehicle in park, turn it off, and toss his keys out the window. Licensee put the vehicle in park and turned off the engine. However, he refused to toss his keys. Licensee then put the keys back in the ignition and started his vehicle. Police officer, still in his patrol car, sprayed licensee with mace. Police officer then exited his patrol car, reached into licensee's vehicle, and shut it off. He then removed the licensee from the vehicle and placed him into custody. While in custody, licensee appeared clearly intoxicated as he could not stand on his feet, speak, or even answer simple questions. Police officer transported licensee to a hospital and attempted to obtain a blood sample. He read licensee the implied consent law verbatim several times. He gave licensee several opportunities to submit to a blood test. Licensee refused several times. Police officer then transported licensee to the station and arranged a ride for him. Thereafter, police officer filed charges. At hearing, the department also submitted the Form DL-26 chemical testing warnings and refusal report police officer filled out at the hospital and other certified documents related to the case. These items were admitted to evidence without objection. In response, licensee demurred to the department's presentation of its case. He argued police officer's testimony failed to establish he had reasonable grounds to believe licensee was operating a vehicle in violation of 75 PA.CS DUI. Police officer merely testified licensee appeared intoxicated without specifying that licensee appeared to be under the influence of alcohol or a controlled substance. Licensee argued a person who appears intoxicated may be sick or suffering from a medical condition, such as low blood pressure. The trial court denied licensee's demurrer without prejudice, allowed the parties an opportunity to file briefs, and continued the case for 1 week. At the second appeal hearing, the trial court denied the demurrer. The court reasoned. We've come to the inescapable conclusion that it is not necessary for the officer to use the words alcohol and or controlled substances, that the word intoxicated is sufficient when taking into account all of the other testimony given by the officer and circumstances that gave rise to the stop, and considering all of these circumstances, it was clear by implication that the officer's testimony was sufficient to survive the demurrer. So with all that said, it was then denied. Licensee then argued our decision in Schindler versus Department of Transportation Bureau of Driver Licensing appeal is applicable. In Schindler, we held the arresting officer lacked reasonable grounds to believe the licensee had been driving under the influence of alcohol or drugs based solely on his failure to pass the one-leg stand and walk and turn field sobriety test. The licensee had just crawled out of his overturned vehicle following a rollover accident. Holy crap. Here, licensee asserted he had trouble standing or answering questions after being maced. The trial court distinguished Schindler on its fact and denied licensee's appeal. Also, the trial court noted that police officer observed licensees driving through Conshohocken, what is wrong with me? Blowing stop signs, exceeding the speed limit, stopping too long at traffic lights, disregarding multiple requests to pull over, and upon being forced to the side of the road, disobeying an instruction to toss the keys out of the vehicle. The distance traveled, licensee's non-responsiveness to the police officer's request, and his attempt to drive away after being stopped are all additional facts which very easily led the police officer to the conclusion the individual is intoxicated. And Kevin appealed that. Says at the bottom here, our review is limited to determining whether the trial court's necessary findings of fact were supported by substantial evidence or whether the court committed an error of law. Licensee again contends the trial court erred in denying his appeal from suspension under 75 PA.C.C, refusal to submit chemical testing because the department failed to establish police officer had reasonable grounds to believe licensee was under the influence of alcohol or drugs. Licensee argues that the police officer's testimony fails to establish any connection whatsoever between licensee's driving and alcohol or a controlled substance. Police officer never asked licensee if he had been drinking or doing drugs. Licensee never stated that he has been drinking or doing drugs. Police officer did not testify that he smelled any alcohol on or around licensee. In order for the department to suspend a person's driving license for refusal of chemical testing requires that a police officer have reasonable grounds to believe that the person be in violation of 75 PA.C.S or a DUI, as that provision relates to driving under the influence of alcohol or a controlled substance, specifically section 1547 provides. A. General rule. Any person who drives, operates, or is in actual physical control of a movement of a vehicle in this Commonwealth shall be deemed to have been given, and this is continued on the next page, but we're going to continue to read this actual court case. Now this continues and says here licensee, aka Kevin, asserts police officer determined licensee to be intoxicated based on the traffic violations, slurred speech, unsteadiness on his feet, and his inability to follow simple commands. For purposes of argument, licensee stipulates police officer had reasonable grounds to pull him over for violations of the vehicle code. Although licensee concedes the traffic violations, he contends the other factors cited by the police officer resulted from him being maced. Traffic violations alone are not an indicator of intoxication. Speeding and following closely do not themselves provide reasonable grounds for a police officer to believe that licensee was driving under the influence of intoxicating substances. Further, licensee asserts being sprayed with mace provides a reasonable explanation for his slurred speech and unsteadiness on his feet. I'm sorry, I've seen people get maced on cops plenty of times, okay? The show Cops is wild, especially the body cam ones, but I've seen people get maced plenty of times, and from what I've seen, it does not slur your speech. Sure, it can make you probably a little bit unsteady on your feet, because that shit, it's painful, but I've never seen anybody start slurring their speech after they get maced. It says here, mace is intended to disable an individual, causes dizziness, extreme general discomfort, and accelerated secretion of saliva. Therefore, licensee urges the department's evidence fails to establish police officer had reasonable grounds to believe that he was driving while under the influence of alcohol or a controlled substance. Now the court continues and says, we disagree. Reasonable grounds exist when a person in the position of the police officer viewing the facts and circumstances as they appeared at the time could have concluded that the motorist was operating the vehicle while under the influence of an intoxicating substance. This is determined by reviewing evidence as a whole, including the licensee's general appearance and behavior. The test for determining whether reasonable grounds existed is not very demanding. Now it says here, Hassan versus the Depth of Transportation, Bureau of Driver Licensing 866, A.2, all those number things. A police officer may rely on his experience and personal observations in rendering an opinion as to whether the driver is intoxicated. Unruly, disorderly, or unusual conduct is a sign of intoxication. After reviewing the totality of the circumstances, we agree with the respected trial court that the licensee's unruly or disorderly conduct prior to being maced could have been objectively construed as intoxicated behavior. In particular, licensee's repeated failure to respond to the police officer's directions to pull over and his attempt to drive away from a forcible traffic stop provided the police officer with reasonable grounds to believe licensee was driving under the influence of alcohol or a controlled substance in violation. These circumstances support police officers' lay opinion that licensee was clearly intoxicated at the time he was stopped. Further, although police officer did not testify that he detected an odor of alcohol on licensee, the absence of such testimony will not render police officers' other observations insufficient to establish reasonable grounds to believe that licensee, aka Kevin Cooney, was driving while under the influence of alcohol or drugs. Then it says here to see Pickens versus Depth of Transportation. Police officer need not detect odor of alcohol to have reasonable grounds to believe a person is driving under the influence of alcohol or drugs. A driver's bizarre behavior may provide such reasonable grounds. Finally, although licensee attributes his condition to being maced, the existence of a reasonable alternative conclusion does not preclude the officer's actual belief from being reasonable. In the Commonwealth Court of Pennsylvania, Kevin M. Cooney, Jr., versus the Commonwealth of Pennsylvania Department of Transportation, Bureau of Driver Licensing order. And now, this 24th day of March 2011, the order of the Court of Common Pleas of Montgomery is affirmed. Now, it says here when a court case is affirmed, it means that the higher court, usually an appealing court, has decided to uphold the lower court's decision. Essentially, the higher court agrees with the ruling and it stands as the final judgment. Could y'all imagine flipping your vehicle because you're intoxicated just to crawl out from it and be like, yeah, I'm not intoxicated. Could y'all imagine driving intoxicated at a high speed of rate? Like, you got places to be, you're driving that fast, just to sit at a light after it turns green. Could you imagine making eye contact with the officer that is trying to arrest you just to not comply with what he's trying to say? Now again, this was from 2011. This is in the state of Pennsylvania. This is a separate case from the drunk driving incident that was dated back in 2012 from him in Connecticut. So it's safe to say that Eugenia's dad had a alcohol addiction and struggled with it and has a lengthy history under his belt when it comes to actual arrest and run-ins with the police officers for drunk driving. Not a lot was known about the dad. He was that creepy father figure who would just pop up in her stream every now and then and tell her how she don't look a day over 14, or just burst into her bedroom door as a grown woman and grown teenager without knocking. I don't know about y'all, but this dad rubs me in all the wrong ways. Like, I just don't get a good vibe from him. I don't know. And can you imagine trying to fight the court like that? That's embarrassing. And what's crazy is not everybody with status and power and money is like this, but he definitely is egotistical, allegedly, if he's really trying to fight the court and the police officers and be like, well, this won't hold against me. You know, I don't know, y'all. This whole situation is absolutely bizarre. I'm going to consider this like a part 2 in this 3-part series of the dad so far that we have had on this channel. The first video I ever made about him, if y'all hear noise in the background, that's the kitten. So the first video I ever made about him was that drunk driving incident in Connecticut back in 2012 that happened December 23rd. Second video I made about him was the video we made yesterday, talking about the actual attempt of unaliving Deborah while he was highly intoxicated. Now this, his court case in the Commonwealth of Pennsylvania. Now, why am I covering this? Because when I first started covering Eugenia Cooney, we always talked about in the comment section and asked each other the questions. What was the home life like for her as a child, as a teenager, and even in adulthood? What's the status of the household? How do the people in that household function? What is the mindset of the adults in that household? And we're finally starting to find out. Again, this video is all alleged for legal reasons, and all of these files and everything that we have looked at over the past couple of days, these are all in the public domain. These are all public records. These are things that y'all can literally search at home and find. I in no way, shape, or form am trying to breach anybody's privacy or defame anybody or spread around defamation. I'm genuinely just reading the things that we find online about the actual chaotic Cooneys. I was actually sent stuff about the mother as well. So, y'all can expect that in tomorrow's video. With that being said, we're almost at the 30-minute mark, and that's where I like to keep my videos. So, go to the comment section, y'all. This was a crazy video. This was hectic. This was a lot of information, even though it was just one court case. But I feel like we're looking inside the mind of Kevin Cooney and what he thinks, how he feels, and his God complex and superiority. But with that being said, again, everything in this video is just alleged, even though it's it's all there, proofs in the pudding. But let me know in the comment section what y'all think about anything we just discussed in today's video down there. I can't wait to read your comments, and I will catch you in the next damn video. Alright, bye. AKA, don't sue me. Just don't sue me, okay? This is all, it's all public, okay? It's out there.